Good evening, everyone. It gives me a great deal of pleasure to once again welcome back our superstars. And I say once again, because this is a series that we've done on young lawyers on the go. Young lawyers on the go. And what does that mean? That means that we have featured the best and the brightest in this country, the most talented lawyers, not the most talented African-American lawyers. Hear me, ladies and gentlemen, the most talented lawyers, young lawyers who are moving and grooving. You know, we say in my day, shaking and baking, moving and grooving and doing all these wonderful things. And I say to people from my group and more seasoned lawyers that we have so much that we can learn from them. I just came up with a theory of aging. So Winter was a law clerk many years ago, almost 2 decades ago, when I was a partner at the Gary firm, and we tried a big case, a commercial case, many years ago, as I said, almost 2 decades ago. And she was a law clerk and I was a partner. And what has happened is her expertise level has gone off, she's off the chain. So as she's risen with her expertise, her skill set, and her remarkable talents, my age has decreased, you see. So before I was up here in age, she was here in experience, she's come up here in experience, and my age has gone down. It all balances out that we are all peers. We are all peers. And that's my story, and I'm sticking to it. So ladies and gentlemen, it gives me a great deal of pleasure to introduce, and I'm going to call them by their first names, and they're going to introduce themselves more properly. Bianca, Anthony, Melanie, Winter, our superstars who I would put up against anyone in the ADR area, who are going to talk to us about how you build a successful legal career through ADR. So that is extraordinary. I want to thank you all in advance. Ladies and gentlemen, I have less than a month as president of this magnificent organization. It has been a labor of love, and there's no better tribute to me than to feature the folks, the young folks, men and women who are our future, who are, as I said, moving, grooving, and taking no prisoners and making a difference. So against that backdrop, Winter, I think I'm turning the program over to you, or maybe it's Melanie, or maybe it's Anthony, or it could be Bianca, but I'm turning it all over to you all since we're all peers. We've established that. Thank you.
Thank you, President Hoffler. My name is Melanie Petway. I am one of President Hoffler's Deputy Chiefs of Staff, and we have assembled today a wonderful group of panelists with an expertise in mediation. Anthony Franklin will be our moderator, and we have Bianca Motley Broom, and we have Winter Wheeler, who will tell you all of their wealth of knowledge about mediation. I'll turn it over to Anthony.
Thank you, Melanie, and thank you, President CK. So I want to thank you all for, first off, hosting this very timely program. I don't know about many of you all, but if you're like me, when you decided to go to law school, you were very much excited about the prospect of having your day in court and showing up and having that you can't handle the truth moment, and you just making a witness cry on the stand, and all the things that we saw on TV. You were going to do that when you became a litigator in court. And then you enter the practice, and as soon as you think you're getting ready to go to court, you get that nice little order from the court telling you you need to go to ADR and mediation, and you will not be having your day in court. So this series is very timely as young lawyers, as we understand what exactly does it mean to be referred to ADR, and more specifically mediation. What is mediation? What does it look like? What are mediators looking for? And what are some of the trends we're going to see in mediation going forward as we see a reduction in the number of civil cases going to trial? So I also want to set the bar properly. So all the flattery remarks and compliments you heard about how stellar this panel is, it truly applies to the panel. So this panel is absolutely amazing. If you get a chance, I would definitely encourage you to visit their websites. You will see how extraordinary this panel truly is. And with that, so we're going to start with some brief introductions and background. So I'm going to ask both of the panelists to kind of just introduce who they are and just let us know what their backgrounds are in the law. So we'll start with you, Winter.
Hi, everybody. My name is Winter Wheeler. I am a mediator and arbitrator, primarily at Miles Mediation in Atlanta, Georgia. I'm available online throughout the country, also in Turkey and India. I've been a full-time mediator since 2019. I was a litigator exclusively for about 14 and a half years. Loved it, loved it, loved it. But mediation is always where my heart was. And I spent those 14 years building my skill set, doing primarily insurance defense work to get to this point so that I would be a successful mediator, truly. The other things that I spend my time doing, I'm the creator of the 4 cornerstones of mediation. It's a mediation methodology that I've trademarked. I'm a 2-time TEDx speaker. One was focused on the 4 cornerstones of mediation. The other should be available for review on YouTube within the next couple of weeks. So that'll be out soon. And I'm also the creator and host of the Mediate Now podcast, which, of course, as you can tell from the title, is about mediation. Who wants to talk about mediation 24/7? Me. Yeah. Was there another question, or was I just supposed to introduce myself and then answer the question, or just introduction?
No, that was perfect.
Okay. Oh, and I work with Bianca, so I'm lucky.
Oh, I am the lucky one. And Winter and I actually have very similar backgrounds in terms of our practice. Both of us did some insurance defense work. I actually started off my career as a prosecutor in Cleveland, Ohio, and then transitioned into insurance defense work and really loved the practice, but saw during the time that I was practicing law that mediation was where things got done, and where we could have these open, honest conversations about the good, the bad, and the ugly of cases. And sometimes when you are litigating and you know you've got that ugly, but you just got to keep on pushing forward, and you're not exactly sure how to hit the exit button. Mediation can help that, because gosh darn it, you never want to lose face. And so it has been a great opportunity for me to not only use the building blocks of my legal career, but just my natural inclination to connect with people. That's also led me in another direction, in that I am the 27th mayor of College Park, Georgia. I started that a year and a half officially. Today is the June 30th, so I'm 18 months in. I am the first woman and the first person of color to serve as mayor of College Park in its 125-year history. So that's me in a nutshell.
So like I said, this panel is amazing. I'm just lucky to be in the same Zoom space as you all. Let's kind of pick up where, Bianca, where you left off. So you talked a bit about some of the benefits of mediation. And I guess for both of you all. So for me as a litigator, like I said, my goal, my dream was always to be in court. And it sounds like mediation is becoming more common and something that a lot more courts are requiring litigants to undertake before going to trial. So for each of you, what are some of the benefits that you think mediation offers that you may not get if directly to trial?
I tell people all the time, it's certainty, clarity, closure. Because if you go in front of a jury, you've got 12 people, and I think jurors work really hard. I really do. I think they get back there and they try their best to figure out what's fair. But a lot of times that may not be what a party considers fair, either party, in fact. So you get the control as well. And that is powerful, because a lot of times what leads people to mediation in the first place is a situation that is out of their control. So for the first time, they're actually able to say, this is the direction I want this case to take. And you don't get that in a courtroom. Everybody else is telling you what's going to happen. And certainly in the traditional litigation process, it's very regimented. You know, you're doing discovery, you're doing depositions, all of these things are happening. But especially for a layperson who doesn't have particular sophistication in the litigation process, it can just feel like all of this stuff is happening around them and to them, but they don't have control. So I think that's one of the huge benefits, is being able to put the process or put the decision making back into the hands of the parties.
Yes. And for me, one of the things that I like to focus on is we're talking about having that big trial day. And that's really important to a plaintiff. Typically, we're talking about the plaintiff needing that cathartic release, right? Sometimes the defendant as well, but typically it's the plaintiff. A lot of people believe that on their trial day, the judge is going to listen to them and hear their whole story, their life story. How has this affected me? And that's just not what's going to happen that day, right? We know that as attorneys. And so at mediation, they can do that. I can sit there and I can listen to them. I can hear them out. I can give them the feedback that they need. I can affirm their feelings. I can make them understand, you're not crazy. It's not always fair. It's an algorithm that they're using. I get it, and give them all of that emotional support and emotional feedback, which is really better than what you're going to get on a trial day. And, just kind of piggybacking off of what Bianca said, it's that certainty. So not only are you going to be seen and heard and validated, you're going to have guaranteed money in your pocket. And it's going to happen. It's going to happen right now. You're going to have that money within about 30 days, maybe less. It's a promise of cash and quickly.
Especially given where we are in our country and our world right now with COVID. Switching gears and hats a little bit, on the mayor side, I get to hear how counties are doing. College Park sits in Fulton County, which is the largest county in Georgia, but part of it is also in Clayton County. And so I hear on updates how the courts are doing. And it's not great. It's just not great right now, because we have counties in Metro Atlanta that have 3-year backlogs. So when we're talking about folks who may have had something occur in 2017, 2018, 2019, and you might get your case heard in 2024, that is so not satisfying for a person. And as Winter said, I think when you go into a courtroom, or what do you expect of a courtroom, right? You've seen it on TV and you think you're going to get up there and there's going to be lots of drama, and then you realize, no, there's really a lot of paper pushing. But we all know, as lawyers who have tried cases, that it's also one of the most stressful things to actually be trying a case. Just being in the courtroom and trying a case, I've never felt that sense of awareness of my being as much as when I try a case, because that someone's looking at you the entire time. That pressure, that sense that you have to be a certain way. For the layperson, typically, as Winter said, the plaintiff, they can be themselves in mediation, and that's okay.
So
You can come in and yell at me. That's fine. I don't take it personally at all. I just got here. I know you're not upset with me. It's okay. But the same things that might endear you. Hello, Danielle Turnipseed. I see you in the chat box there. But for the folks that are that may not feel comfortable in a courtroom, they can be okay in mediation. And that's really exciting, because again, it gives you that space to not only get your case resolved, but do it by being yourself, and not having the pressure of 12 strangers getting into your business either. Because some of the things that we talk about within the context of litigation, I was actually just thinking about a case that I had probably about a year ago, where I had to, we had to sort of delve into the fact that the plaintiff was morbidly obese. And I had to have that conversation with her, and it wasn't a pleasant one, but it was something that was going to impact the outcome of her case. And being able to establish a connection with someone, being able to have those open, honest conversations, I think really helps for people to gain more information about their case and see it from a different perspective than the one that they might have come in with.
Absolutely. And it reminds me of a case I had a little bit ago. The plaintiff, he was convinced he had a much stronger case than he did, right? And the plaintiff's lawyers, they had instructed me to be tough on this guy. He was not listening to them anymore. He had recently gotten out of prison. He'd been convicted of bank and wire fraud. So these are things, they were federal crimes. He got out of federal prison. These were things that were going to be entered into evidence against him. They went against his, veracity and all of this. And so I'm having this conversation with him about how the jury will, more than likely hear this information. And the jurors are going to know, and they're going to be judging you and kind of sizing you up. And he said, well, how dare those lawyers judge me? And I said, well, they are or they aren't. They're just kind of using what's in their tool belt, right? It doesn't really matter what the lawyers think. It matters what those jurors might think. And the jurors aren't here today. We can value your case for what your case is actually worth today. Kind of in that vacuum without thinking about what your conviction, the effect your conviction might have. So let's focus on that. Let's think about that today. And that was really helpful. And he got to vent about how unfair he thinks life has been since he got out of prison, and how people have been judging him and on and on and on, which of course is not something he would have done in a courtroom. It wouldn't have happened. So, I think Bianca was dead on with that.
So you both raised interesting points about sort of the roles you play as mediators. I mean, you talked about almost kind of like a counselor slash, helping out with come to Jesus moment. You're the person who can be sort of the voice of reason when the attorneys can't get through to their clients. So I guess for each of you, how exactly would you describe the role of the mediator? I mean, you're not really a judge or jury in terms of, you're not evaluating the merit of the case, it sounds like. So what exactly is the role of a mediator?
Well, I always say that mediation is a series of uncomfortable conversations, and I'm the person who facilitates those conversations. I'm there to make sure that you've heard the other side's arguments, and I'm there to make sure you've heard everything that I think about it. If it's come to mind for me, it'll likely hit a juror, right? So I'm not there to sugarcoat for you, but I'm not there to hurt anybody's feelings either. But I'm not doing my job if I haven't brought all of that information to light and helped you think about all of it. I consider myself almost kind of like an interpreter. I'm helping get that information from one party to the other and making sure it is done in a way that each party can actually hear and receive it. Because this is not the first time that they've communicated, but it may be the first time that they've communicated effectively, right? They couldn't do it themselves. They're doing it through me. And mediators are trained to communicate with different people. That's what we are experts in. So I'm an expert in having uncomfortable conversations and communicating effectively with various people.
I wholeheartedly agree with everything that Winter said. I think no matter who you are, no matter where you are, you want to be heard, respected, and acknowledged. Again, in the litigation process, there are a lot of ways in which people don't necessarily feel like they've been heard, respected, and acknowledged. So a lot of what happens when they reach us is that particular process. Because by the time people are mediating, although I would encourage people, if you know the facts of your case and there's not that much that's going to change, do it earlier in the process. But a lot of times we'll see cases that have been around for several years, and there's a lot of frustration there. And it's frustration that they're not going to be able to get out in a courtroom for evidentiary rules and all of that. We know how that works. In Georgia, the word insurance will never be uttered in a courtroom. That's how it works here. And given that, especially when you're dealing with an individual plaintiff who might be, you know, it's a personal injury case, for instance, and there's an insurance company on the other side. There can often be a lot of hard, raw feelings about how someone's been treated in that process, that people don't care about them, that, you know, I'm just a number, all these things. We can tell them, you do matter. We're here today focused on you, and you're the most important person in the room, and you get to make all the decisions today. And there's just so much power in that. There really is. And when you get right down to it, when you set the emotion aside, which can be a difficult task. I mean, a lot of, I think early rounds of mediation are often spent on the emotional components of a case. But when you set the emotion aside and you just look at the risk reward of going to trial, most people don't want to do it. I mean, my 93-year-old grandmother would take the risk every single time. She's a gambler. She loves it, right? She loves the slots. Anytime you can take a chance, she's going to roll the dice. But most people do not have that same sense, especially when they're dealing with things that are so close to them. They don't really want that risk. They don't want to leave it up to 12 strangers to decide their fate. So when you're able to peel away the layers and get to the heart of the matter, then you get resolution, which just thrills me every time. Honestly, I get so excited. I mean, I last week, I think, an attorney was kind of making fun of me because I said, "Oh, we have a deal. Okay, great." He said, "Okay, you were pretty excited." I was like, "Yeah, I was." Because it's always great because I know what that means for everyone. And it's really rewarding. And I'm glad I'm able to be in this position to help parties get there.
So you both talked about sort of peeling back the layers and trying to understand and really get to the heart of the issue. And in some ways, that sounds a little different from what we're taught in law school, where we're taught to be the advocate and, you advocate for your client's position and you're zealous and you're not really taking that time necessarily to sort of see the other perspective or, like you said, get to the heart, peel back what's really going on there. How do you both feel that being a mediator has either made you a better lawyer or improved your lawyering skills by virtue of being a mediator?
Well, I don't litigate anymore. I've never done both at the same time. So I don't know the answer to that.
I haven't either. I transitioned from full-time practice to mediation, and then I was a part-time judge in Fulton County Magistrate Court. I tell people all the time, I'm not wearing the lawyer hat today. It certainly informs the way that I look at the situation. But I'm not here as in a mediation to be an advocate, because I want people to understand that I'm not here pushing any particular side. And the beauty of us coming in is that we have fresh eyes. And sometimes parties and lawyers even can have a case so long, it's like when you stare at a word so long that you look at it and you think, is that spelled right the right way? And so if you've looked at a case for so long, sometimes the facts and the little details that might pop out to someone who has just looked at it, it is completely different than what you see. So I think it gives us a great perspective to be able to just not have that sense of attachment. I served as the board president of a local charter school, and I didn't have any kids at the school. I don't have any kids, and it was great, honestly, because a lot of the folks who were on the board also had kids in the school, and it made their perspective very different than mine, because we all see things from where we sit. I learned that every day as the mayor of College Park. If that pothole is right in front of your house, that is the biggest thing going on in your world. it does not matter if we have a water main break 2 miles away, if your water is still on. We got to get that pothole fixed. And so you have to respect that no matter where people sit, they have a particular perspective. And helping them open that up, see things from someone else's is it's a challenge, but I consider it really fun.
Yeah, definitely. Lawyers get myopic. And what I realized when I started mediating full time and exclusively was that I had been very guilty of that myself. I had neglected to think of many people that I came across, many of the parties, as real people. I was so excited about the puzzle of the law, the game, and winning, and what I was able to do, and advocating and writing the most amazing brief, that it was all about me, right? Like what's my scorecard look like? And now it's more about how am I going to bring a resolution to everybody who's here? How can I bring these parties to a resolution? And it's, I tried to make sure everyone is satisfied. And you can only have a resolution if everyone is satisfied. They both have to agree to the number, right? So no one is winning, no one is losing. They're all coming to an agreement. And that's a very, very different position to be in. Not trying to win, not trying to make sure someone else loses, but making sure everyone is comfortable. It's just, it's an amazing position to see people come in and go through this experience. And it's like watching a transformation sometimes, having them come in very upset, very nervous, get all of this out, all of this emotion out, and then when they leave, just you can see that kind of weight having been lifted off of them. And knowing that I was part of that, it's just beautiful. It's an amazing thing to see. And so I think, again, I agree with Bianca. I think I agree with Bianca all the time.
I was going to say, I'm not sure that you're going to find a point that we disagree on.
I know, right? I love Bianca.
I love you.
So it's just not having to ever be in a position where I'm advocating anymore makes it, I believe, a lot easier for me to be neutral, because I'm no longer looking for that defense hole. Like, do you know what I mean? Like, I'm not looking to poke any particular type of hole in anybody's case.
No, that makes sense. So let me kind of follow up on that a bit then. And I guess this goes back to something Bianca mentioned earlier, just in terms of, I know for many of us litigators, we have seen sort of a backlog in the courts. And especially like I'm here in Houston, and yeah, I don't know if we're going to court anytime soon with this current backlog. And so it does seem like mediation is a way to sort of get your case before somebody who can sort of fairly evaluate it and get a resolution, like Winter is saying, in which you both hopefully all walk away satisfied. And to Bianca's point, we fixed that pothole right in front of your house now, as opposed to having to wait 2-3 years later when the courts sort of open up. So given this current trend for COVID, how would you all say that this has impacted mediation? I mean, between having to do things like we're doing right now online and having to use Zoom for appearances, how has COVID impacted the way you all mediate? And then the follow-up to that is, do you see this trend between cases being referred to mediation and or having to use this sort of virtual setting for mediation? Do you see that continuing in a post-COVID world?
Well, since Georgia never really closed, I don't know.
I'm closed for a little bit. Yeah.
Slightly kidding.
Yeah.
Other than having to mediate online, I don't know. I didn't see much of a difference, frankly. I think, and then I say having to mediate online, it actually became kind of a blessing. It really works in a lot of situations. It can be very beneficial in certain types of cases. Some types of emotionally charged cases, it can be very nice to not have people physically in the same space. Sometimes with family situations, that's very helpful. Just for example, and I think it's definitely going to stick around. I have a lot of clients who really like this platform, and I do not see it going anywhere anytime soon. I've got a lot of cases that have been kind of in a hybrid model where I'll have people who want to appear in person and then other people who want to appear by Zoom. So I get to, walk around with a computer during the day. And that's fine. I mean, it's convenient, it's easy. And what's really great is that it means more people are able to participate. People are more readily available. They can work a mediation more easily into their schedule. They're not having to travel. And I mean, I'm like, when I was introducing myself, I'm able to mediate in Turkey and India all the time. Like, I'm not flying out there. So it's been wonderful for me.
I think it's changed the way that we're going to do business moving forward. A majority of my cases now are virtual. I mean, it's starting to tip back because there is value to being in person and seeing each other and being back in the office, but I don't foresee a time when we don't have this option for people. I had a case a couple of weeks ago where uh, the plaintiffs were in St. Louis and they didn't have to travel to Atlanta to get their case resolved. Great. They were just as engaged, just as involved, but they were able to save money and time and still get resolution. Now, in regard to the court system, I think it's going to be, I don't know how that's going to work. I got called for jury duty in Fulton County right before Memorial Day. I think it was the week before Memorial Day. And we had to appear via Zoom, and everyone showed up at 8:30, and then they put us in a breakout room to check us in, and then put everybody else, like once you got checked in, then you went into a larger pool of folks that had been checked in, and we sat there for an hour, and there's 80 people in the room, and 5 of them don't know how to mute. And then there was one woman who was in her robe and had a hacking cough. I mean, and then one woman who was yelling at her kids. Like, honestly, I'm not even making this up. This is exactly what happened. I don't know how voir dire was really going to work. I can't imagine trying to do voir dire that way. And it turned out that at about 9:30, they said, well, they've resolved the case. We'll send you your $25. So I was glad for that, because I think it would just be a really, really hard thing for lawyers to navigate. It's one thing to have a conversation and you've got parties who are engaged, but literally there was a woman yelling at her kids at the same time. This lady had a really bad, I don't know, I'm hoping it was allergies. And so the dynamics of that just didn't seem like they were really going to work. And if that doesn't work and people don't feel comfortable returning in person, and there still is a level of hesitancy surrounding that. We've got the Delta variant out there, and we don't know how that's going to impact things. And here in Georgia, I think we've got about less than 40% of the population that's fully vaccinated. So,
No comment.
okay, we're gonna keep on moving. But even if you're not wearing your mask, and you're not wearing your mask, and 60% of the people are not fully vaccinated, I think things are going to happen, and we're eventually going to see another spike, unfortunately. I mean, I hope it doesn't happen, but if we hit those kind of speed bumps, that's going to put us back even further for getting some sense of normalcy in our courts. We're really the only option that has been going throughout the pandemic. This has really been the only way that you're able to resolve cases. So I think people have gained an even greater appreciation of mediation over the last year plus and recognize the value of it even more.
Definitely. Yeah.
So I think you both raised good points, and I agree with you. I think mediation, at least for the foreseeable future, does seem to be the most efficient route in some cases to get matters resolved. And who knows how long we'll be dealing with a lot of the issues with COVID and the like. So, transitioning a little bit, I want to focus now on mediation tips. So, you both mentioned that you're former litigators who now do mediation exclusively. And so you've seen it now from both ends. You've been both the advocate, but you've also been the person now who is being the neutral, if you will, to sort of help the advocates resolve their case. And so, what advice and tips would you all give to young lawyers, both generally in terms of how to approach a mediation, how to deal with mediation, and then more specific to this virtual mediation format? So, Bianca, you mentioned the idea of people not knowing how to mute. And I think earlier someone said, there was a concern with the volume. So, what advice would you give to young lawyers who are generally preparing for it to either do their first mediation or to mediate cases, and then anything specific to virtual mediation that you recommend people either learn to do now or can do a better job of?
No matter what the format, be prepared. Use this as your day in court, because you have the opportunity, if you're a plaintiff's lawyer, to zealously represent your client and get a case resolved. And advocating for your client we can work with you on that. Like, I understand that there is a certain level of zealousness that attorneys need to show, no matter what side they're on, because you've got to prove your worth, and you've got to show to your client that your skills are top notch. Use that opportunity at mediation. Come with, if it's a Zoom mediation, be prepared to share your screen, highlight all those documents, have them ready, because there are going to be things we're talking about. Know your case. I think one of the most challenging things for me is trying to elicit information out of a party who doesn't know their case. And you don't want to be in the position of me or Winter or any other mediator you select to come in and tell you things you should already know. That's a bad look in front of a client. So that would be the really big thing, because I think sometimes people see mediation as a box you check and you keep on moving. But the more prepared you are, the better your chances for resolution, and the better opportunity that you have to show your client exactly how good of a lawyer you are.
Yes, absolutely. I unfortunately, I see a lot of people show up unprepared. And it's really, really unfortunate, because you're not doing yourself or your client any favors. Because you really don't want to show up and surprise anyone with information, right? Looking specifically at insured defendants, the insurance company has decided how much money they're going to bring to the mediation table, maybe a couple of weeks, a week in advance. If you show up with a big bill the day of, they're not prepared to take that into account. They just aren't. They're not going to have that money for you. So it is really, really awful whenever that happens. So make sure you have all of your medical bills. Make sure you actually understand what all of those bills mean. Make sure you know what the fair market value of those bills should actually be. Are they inflated? Find out. Figure it out. Because the insurance company is going to know whether there are, and they're going to tell you how much they're actually going to consider. Be ready for that. Don't let me be the first person to tell you that this bill is being considered inflated. Make sure that you trust your mediator. research your mediator. Make sure this is somebody that you can trust. Reach out to them in advance. It's of no help to you if you don't trust me. I'm there to help in the sense that I negotiate. I watch people negotiate every single day. If you ask me my opinion, I will give you my opinion because I see these cases every day. Ask, you know, don't use your mediator as a messenger, right? We're not letter carriers. If you do it right, we're not there to just pass numbers back and forth. We can be sounding boards. You can ask us our opinion. We're more than happy to give you those opinions and help you out in that regard. Typically, we like for you to ask before we just start spouting off, though. But yeah, that try to build that trust with your mediator. And like Bianca said, be prepared to make presentations, use your share screen. Not only are you going to impress your client, you can impress the other side by putting on that show, that big show. You kind of show them what you're capable of too, right? And what a trial against you might look like. What is it going to sound like when you put all of your positive information together, and how you might impress this upon a jury? I mean, and all of that just looks really good in front of your client, and a layperson is going to be like, yeah, that's my lawyer. They know what they're doing. And this is all very positive, and it helps. And when your client has more confidence in you, no matter what that ultimate number is, if you tell them to take it, they're more likely to listen to you.
And I'll add one thing. If you're having client control issues, it's so good to let us know that
in advance, please.
Yeah.
Call me.
Let us know. Let us know. I mean, we could go around for about 2 hours, or you can let me know that ahead of time. Yes. And that's fine. However you need us to approach it, we can absolutely do that. But if we're walking into a hornet's nest, it's good if we are wearing a bee suit.
Yes, 1,000%. I had a case not too long ago where the attorney called me in the morning and let me know my client is passionate, to say the least. And I have done my best, but I'm going to need you to be tough. Teach him about the law. Tell him everything. Don't let up. Be relentless with this guy. I said, okay. And so that's how we handle it. And then there are some people who say, I would rather you not tell my client too much. They're already kind of wishy-washy on things. Like, let me handle it. However you want to do it. I'm there to help you. I can help make you look good. I want everyone to be happy. I want us to reach a resolution. However we have to do that. I'm happy to figure that out for you. We're adaptable people. That's something that mediators are good at.
You both raise a good point about clients. I mean, there are some clients who, they take to heart what you as their lawyer tell them to do, and they will listen and they will, follow kind of what you're telling them. And then there are others, to use Winter's term, that are very passionate, who no matter how much you try to tell them or coach them, they are just going to do whatever they want to do. So in terms of preparing for mediation, how do you recommend that young lawyers prepare their clients for mediation? I mean, it's not like a trial. It's not like something, where you're going to court advocating. So what advice would you give about the conversation and how to prepare your client for what to expect at mediation?
Be honest with them. There are so many lawyers who try to avoid their own clients. It happens all the time. And they allow their clients to have unrealistic expectations coming into mediation. They'll come in thinking they're going to get home run numbers, the types of numbers that, you would only get if a jury believed absolutely everything you said and they were like, I don't know, high. Things you're not going to get that are not compromised numbers, right? And so I typically end up telling plaintiffs, on your average day in this venue, with these medical bills, with this whatever, this is typically what you would be looking at, this range, right? And that's if they believe everything you say and they don't believe anything that the other side says. That this would be the range. So if you have $20,000 in medical bills demanding $100,000 today, that's not likely to happen because you wouldn't get that at trial. It makes no sense for anyone to settle for that. Even if they went to trial, they still wouldn't be out that money, right? That's not a conversation that I should be having with them. Well, I can have that conversation. It shouldn't be the first time they've heard it. Have conversations with them about what realistically could happen at mediation. Obviously you're pushing to get as much as you can, but be realistic about what those numbers look like. Those are compromised numbers. You are the insurance company is trying to save money. They want to spend as little as possible, and the plaintiff is trying to maximize and get a guaranteed amount of money in their pocket, right? So everybody is compromising. So you're not going to get home run numbers today. So let's not spend 5 hours with me just trying to talk you into like getting on the playing field. So, let's show up in the morning ready to get on. I mean, like, I don't know, the outfield, at least the outfield.
Parking lot. How about
Parking lot, maybe.
Yeah, I mean, like you don't have to get on the field. Like parking lot would be good.
Not the stratosphere.
No, right.
At least the
right,
parking
exactly.
lot.
Yeah. I can't argue with that point either. I think it is. People walk into mediations with great expectations a lot, and what we have to do. I mean, there are a lot of ways to do this, but because we have the real privilege of walking in kind of cold, we'll get mediation statements and the like, but we haven't lived this. You can take or leave whatever I say. You don't have to listen to me. It's fine. Mm-hmm. I'm going to walk away from this either way. Like at the end of the day, whether that is 2 o'clock, 5 o'clock, or 9 o'clock at night, when I leave it, I'm done with it. I'll help you resolve it afterwards if we don't get there, but you still have to sit with it. This is still a conflict for you that's going to be on the front burner if we do not resolve the case. And that has value. Resolution in and of itself has value. That it is not at the top of your list or even in the top 10 of things that are sitting there eating at you. That's got value. Never mind the fact that money in your pocket now versus money 3 years from now. But I talk a lot about that because we've had the opportunity, both Winter and I, to see what resolution means for people and the weight that it takes off of them. And I'm thinking about a case that I did recently with it was an auto wreck, bad collision, where the plaintiff was very concerned that there had not been criminal charges filed. And that was what was holding up the civil settlement. I mean, the resolution that we could get to that day was hung up on the fact that on something completely out of anyone's control, right, who was actually participating. But we had to talk that through for him to understand that these two things are completely separate. It had never been a conversation with his attorney. Like, look, we can only do what we can do today. and it may not give you all the peace you want, or it may not be everything that you think is that should happen as a result of this incident. But we can close the chapter on this element and you can move forward. There's value in that.
So we have a question from the audience that I want to get you all's opinion on. So the question is, do you have any tips on opening statements? Any general rules that you suggest young lawyers adopt? Ergo, don't get too deep into the weeds, talk directly to the mediator versus the plaintiff or defendant or opposing counsel. So do you all have any advice for young lawyers in terms of how they can both prepare and approach the opening statement at mediation?
Yes. I think it's effective if attorneys address the parties themselves, because it is one of the few times that you actually get that opportunity. You don't get that chance in court to really talk to another individual. To, if you're on the defense side and you are dealing with an incident, maybe there's not an issue of liability, maybe there is. You can still say, I'm really sorry this happened. You would not believe the impact that has on someone to acknowledge that something traumatic has occurred, because a lot of times they haven't heard that. So I would not waste the opportunity to talk directly to someone. I would limit your openings, depending on the complexity of the case, to, I would say, about 30 minutes or less. And 30 minutes would probably be on the longer end for most cases. I think you can get it in for the most part. If it's that complex, you should have sent us a statement. Because if you're explaining that much in the opening, you don't want to waste time, and time is money. You want to waste time bringing us up to speed on something that complex. Most of the time, the parties in the room should have a very good idea of what's going on. Use it as an opportunity to shine, though, and show. I also think that the most impactful opening statements acknowledge the other side's points, because you say, hey, look, I know what our case is, but I know what yours is going to be too, and we have a very strong understanding of it, and these are the ways in which we think that your argument does not hold water, but you can do all that in a relatively short period of time.
I don't have anything to add to that. I agree with her.
All right, you get the next question then.
Speaking of the next question, so the next question goes to if you all would briefly tell us about, more specifically, how you got into mediation. So what was the training and what were the requirements necessary for you all to become mediators?
I get this question a lot. It's state specific. So I'm in Georgia, and I had to register, and there's actually some debate on whether or not you have to register. So I can't give anybody advice on whether or not they have to register or certify in their specific state. They need to look that up. That can be as easy as a Google search, but that's what you need to do. You should be able to find that pretty easily, and then you can get the training. Without a more specific question, I really don't know what to tell you. But there's mediation training available everywhere.
Yeah, I mean, in Georgia, it's about, is it 40 hours for the civil?
It's 40.
Course? Yeah. And then
40 for the course, and then I don't know, a weekend of the practicum.
Practicum, and then if you do domestic, and I think both of us are certified in domestic as well. Is that right?
Another 40 or 30?
It's
something like that.
Something.
And then the domestic violence was
longer. I mean, more.
I don't know.
But I think it's,
don't know.
Yeah, yeah.
It's state specific.
It is state specific. But if you are interested, I think you've made contacts as an attorney. You are working with and hopefully with people. I mean, even if you're an adversary, there's a way that you can work in a cooperative manner. And remember that, okay? Because if you're going out there with a scorched earth approach to litigation, it's going to be really hard to then turn around and ask those same people to bring you cases as a mediator.
Probably won't work.
Yeah, it's going to be real tough. So just, get colleagues. You can have a colleague on the other side of a case. And there are lots of ways to handle litigation. And once you are that person who's known to be difficult to work with, I don't care how big your legal market is, it's still small. And people talk about those people who, who are just hard to deal with. And so remember that you're establishing relationships every time you're involved in a case. That's when I decided to go out and become a mediator. And this is going to dovetail a little bit into the question that I saw pop up. Yes, it's competitive. You are paid by, it varies. I mean, we are both with Miles Mediation, and so we're paid when we work. So
what we kill.
That's right. That's right. So it's really important that you've established those good relationships so you can turn around and sort of mind those contacts. Let people know that you're taking this different step. And there are a lot of people who decide, hey, I want to mediate, and they might do it for 6 months, or they might do it for a year, and then they drop off. And so there's going to be that period where people say, am I really in this? Are they really dedicated to this? And so it will be a process. I think it's a worthwhile one. And once one of our mediators said to me, every time you are mediating, you're doing an audition for at least one side, because one side might have thought, hey, let's pick this person, and the other person went along. So give that other party, give the people who don't know you an opportunity to see why you were selected in the first place. And they will go and they'll tell people, and they might get on the listserv for the plaintiff's bar or the defense bar and say, hey, I had a really good mediation with XYZ. And then all of a sudden you start getting cases from people that you don't know at all. And that's really neat. Yeah.
It's extremely competitive. I'm not even going to lie. It is a rough industry. It's hard to get in. It's hard to get started. A lot of people don't make it. A lot of people can't be exclusively mediators.
Like me, I had to go get a mayor job.
Okay, just had to go be the mayor.
That was your backup job? Okay.
Yeah.
Had to go be the mayor.
So that actually kind of feeds into the next question we have is, so to both of you all's point, it takes work. And I mean, the idea of you need to make sure that you are constantly putting in the work to make sure you're getting people referring you. So the question is, for each of you, what do you think sets you apart from other mediators? Why do you think people decide that they want to mediate with Winter or mediate with Bianca over, say, some Joe Schmo they could find somewhere else?
For me, I litigated for, like I said, for a very long time. I had a reputation as a litigator for being fair and reasonable and easy to get along with, while still being very smart, tenacious, and pushing with everything that I had for my client, but not being unreasonable. When a case needed to settle, I settled it. I made sure that I had a lot of contacts, Bianca being one of them. I had that's a completely different story, but I had no shame in reaching out to people when I needed to reach out. When I needed help, I asked for help. And then also, you've just got to put yourself out there. And a lot of people aren't willing to do that. I market like nobody's business.
That is the truth. You were on with the queen marketer right here. She's amazing.
I work extremely hard. I invest in myself. I work extremely hard.
I think people pick me because, one, there are not a lot of African American mediators. Many fewer African American women.
Yeah.
Sometimes we're the first people who plaintiffs can relate to, who've been involved in the entire process. And I don't think that you should discount that, because I can ask the questions that we're all dealing with, right? Like I had a case probably a few months ago where the plaintiff was the first lady, and I was like, yeah, sure, I understand why wearing heels are important to you. And her lawyer said, first lady? I was like, yeah, first lady of the church.
He had no idea what you're talking about.
Right. Yeah, exactly. Like, okay, let's yes, I get it. And I had a scarring case recently. We were talking about keloids because I got plenty on my knees because I've had 2 ACL replacements. I get what people are going through in a way that some of the other folks who may be involved with their case do not. I also think that, as I said earlier, I love people. I think you have to if you're knocking on their doors asking for their vote, right? Like, and I think that comes across. I genuinely like being with people. I like hearing their stories. I like connecting with them. And if you don't like people, you should not be a mediator. I probably should have said this at 6:30 instead of 7:30, and you probably would have saved some people some time. But if you don't like people, don't do this, because it is really a fascinating opportunity to engage with people. And I really, really love that. And I think that comes across. And I want people, because I understand the value of resolution and closure, to get to that point. Like, I want that for people. And I think that people see that and they feel it.
So you mentioned it at 7:30, so I do want to be mindful of everyone's time. Let's just go ahead and go to parting words. I mean, so for both of you all, as individuals who have been young lawyers and who are now mediators, any parting words or advice that you all have for young lawyers about either just mediation in general or the practice of law, how not to suck at it, how to have a long career, just any parting advice you all may have.
Sure. Be yourself. Decide what you want to do. Go after it. Don't listen to anyone tell you that you can't do it, because you can. And if anyone wants to connect with me, the best way to do that is on LinkedIn.
And I would say that, yes, go for it. Never regretted walking through an open door. It may not have led exactly where I thought it was going to, but you learn a lot in the process. And if you really want to become a mediator, find the folks who are doing it well. Take the opportunity while you're in a mediation to actually look at the person's skill, because it's not just a conversation. We're not just there to talk. We're actually, there's a process to this. And the really, really good mediators make it look seamless, and you can learn a lot from them. I take one of those folks out to lunch and talk with them about their process, because one of the things that I love about Miles is that we have so many talented mediators on the panel, and I've missed it during COVID, just not being in the office, because sometimes you hit those walls in a mediation, and in almost every mediation, there's a point at which you think, I don't know if this is going to get done. And then you just keep on talking and keep on pushing, and you ultimately reach resolution. I love that. But being able to pick someone else's brain. Gino Brogdon Jr. was supposed to be with us tonight, and he had some family commitments, but I can just vividly remember a situation where I had an attorney who would not let me talk to his client.
Ugh, hate that.
And Gino was there. I said, Gino, I don't know what to do. I cannot talk to someone in the room. They've instructed me not to talk to this person. And Gino said, oh, they're scared. They're scared that something's going to come out. And what it turned out to be was that the attorney knew that no matter what number I brought back into the room, the plaintiff was going to accept it. And the attorney did not want the client to jump at the first offer. And, you know, it's a case where money obviously was the motivating factor. And so, but Gino gave me another perspective on that. He's an extraordinarily talented mediator and just an all-around great person. But just being able to see other people in action, talk to them about it, talk to them about how they've developed their practice, because what Winter and I have done is very different than what Gino has done. Gino has taken everyone in Atlanta out to breakfast. Okay. Like if you haven't had breakfast with Gino, then I don't know. I mean, he's taken everybody to breakfast.
You've done something wrong if you had breakfast with Gino.
So there are different ways to go about it, but you find your own path, the one that fits for you and is authentic. That's another thing. I know you said parting words, and that was 5 minutes ago, but be authentic.
It was.
I mean, it was. I looked at it was 7:33, and now it's 7:38. But authenticity is so important. I mean, just be who you are, because if you're putting on some fake front, it's going to come out. You're not going to, I mean, when mediations get really intense and you're down to the brass tacks, and if you have been faking it that whole time, like, and then you become someone else, then it's really going to be hard for you to get to resolution. Like, just
can
be
smell it on you.
Yeah.
It does not work.
Be authentic in whatever you do. Like, you don't have to be immediate. Just be authentic in whatever you do. It will serve you well, no matter what you choose to do. Just listen to that voice as you'll get closer on your path. You may be practicing now and thinking, this is not exactly everything that I thought it would be. Because let's be honest, the law is not always exactly everything that we thought it would be. And that's okay. That's fine. But you're getting prepared. You're getting prepared for whatever is next. And I'm excited for you because you'll find it. I'll stop talking now. It's 7:39.
And apparently one of my children has had enough of being quiet. So.
Oh, I've got 3 dogs. I'm so surprised that nobody barked. It's a victory. This webinar is a victory.
It was meant to be.
I'll raise you 4 babies.
Oh boy. Okay. All right. I got 3 chickens in the backyard. Does that count?
I think you win.
Okay. All right.
So many more questions, but we're out of time. So I want to thank you both, though, seriously, for taking time to speak with the young lawyers on this webinar. I mean, you all have given us some great insight about mediation. And I know for me, as someone who was not the biggest fan of mediation, especially since it was keeping me from that you can't handle the truth moment in court, I definitely appreciate the insight that you all shared and have a new appreciation, I would say, for mediation. So the next time I'm ordered to mediation, I will not be as upset with the judge for denying me a trial. So with that, I'm gonna turn it back over to Melanie. Any last remarks or anything before we jump off?
all you know, you learn from more fast enough.
Melanie, you're breaking up, Melanie. Melanie, you're breaking up.
But I think she appreciates this. I think I heard appreciate. Yeah.
Appreciate it. Thank you and everyone else. Great solid weekend.
On that note, I think.
Thank you for having us.
Thank you. Yes, it's been nothing but a pleasure.
All right.
Thank you for mediating, Anthony. It was
Thank you all.
Moderating, mediating.
Oh my gosh! See, I've got it on the brain.
You're speaking it into existence.
That's
Like,
right. That's
I'm
right.
stepping into my mediation destiny.
That's right. There you go.
Well, thank you all. And with that, we will call it. Have a good one, everybody.
Take care. Bye-bye.